This short guidance video is one of a series produced by JISC Legal in supporting staff who are directly involved with business and community engagement or BCE activities within their institution. JISC Legal are one of several services that are part of the JISC BCE programme. We will firstly provide a brief overview of issues determining ownership of works created. We will then hear from David Macbeth from Strathclyde University, who will offer you some practical guidance on employee, student and third-party generation of works, as well as the issues that may be associated with joint ownership of intellectual property. Finally, we will highlight the importance of negotiating prior agreements early on in the process. In this video, we want to address the legal issues that will relate to the actual creation of intellectual property between institutions and their partners. The question who owns what is a crucial one, and if not addressed early on could prove very costly for an institution. There are many different scenarios where this will be relevant for BCE activities, where research reports or consultancy work is being carried out, for example. We are aware that there are many other intellectual property rights that will apply within BCE activities. However, for the purposes of this video, we'll be focusing mainly on the issue of copyright. To determine ownership, we must establish which individual has created the work and in what capacity. Section 11.2 of the Copyright Designs and Patents Act states that work produced within the course of employment will, unless there's an agreement to the contrary, belong to the employer. It could also be argued that there's an implied licence in certain circumstances, for example where there's established practice, and this might prove problematic for an institution. To avoid any uncertainty, the institution should consider drawing up intellectual property contracts which make this clear. This will be particularly important where the information is confidential, where that relates to a patent application, for example. Use of consultants can also pose problems for the institution. Without a contract determining ownership, the third party will own copyright in the work they produce. This is not ideal, and instead the institution should try and make sure that the third party assigns their intellectual property to the institution. Where this is not possible, then they will have to negotiate a licence with the third party. This licence should be as wide as possible to ensure for future exploitation of the work. Students will generally own the copyright in the work they create, but again this will be subject to any agreement with the institution. This will be relevant where a student produces materials when on work-based learning, or perhaps they're working with a private partner to carry out research. BCE, or Knowledge Transfer Exchange Departments, might have contracts in place where students assign the intellectual property in the work they create to the institution. This might be in exchange for rights in the commercial exploitation of that work. So consider what provision your institution makes for this already. An institution policy on IPR that considers BCE activities would be advantageous. Where there is joint ownership and a lack of express terms in the agreement, this can be particularly problematic, and this is aptly illustrated by the Cypriotex case involving Sheffield University. This case shows us that where agreements are poorly drafted in general terms without addressing specific products or works being undertaken, then the court will have to make that decision for you. The Court of Appeal in this case found that the agreement was poorly drafted and so awarded the intellectual property, copyright in this case, to Sheffield University at great cost to Cypriotex. The message from this case, loud and clear, is that all parties should explicitly set out at the beginning who will own the copyright in the works created, state clearly who will be licensed to use that product, and on what terms that licence will apply. David Macbeth, the Director of the Research and Innovation team here at the University of Strathclyde, will share with us some of the practical issues relating to student and staff generated intellectual property.
Starting from a staff perspective as far as this is concerned, it's normally relatively straightforward. The university normally owns the intellectual property rights that are generated by its staff, whether they be research staff, academic staff, etc. And that's normally dealt with via the contract of employment, which almost always links university ownership of inventions that are created with a commitment to share revenues with the staff member who has, if you like, created the invention. So the staff situation is fairly straightforward, but where joint ownership tends to come into the equation is where students are also involved, because the default position with students is different from the default position with staff. As far as students are concerned, the default position would be that the student owned his or her intellectual property rights. That default position for students is true in the absence of an arrangement to the contrary. Quite a number of institutions in the UK now make it a condition of matriculation or a condition of registration for postgraduate research students that the institution owns their intellectual property rights. But a lot of institutions, and my institution Strathclyde would be one of them, don't have that kind of condition. What we do is we try to promote with supervisors of postgraduate research students that it's good practice to obtain a confidentiality and assignment agreement in favour of the university. And what that means is that in our case, if staff get their students to do that, the students will be treated the same as if they were staff from the point of view of revenue sharing and so forth. And we think that's good practice in an institution that doesn't have the previous condition that I expressed. The third condition that might apply that changes the student default position is if a funder of the piece of research has stipulated that the funder needs to own the intellectual property rights or needs to have certain control over them. And again, that may change the student's position. So let's just take that scenario where we end up in a situation where we have joint ownership of a piece of intellectual property. Let's say it is a patent application, and the joint ownership is between the institution as the owner of the inventive contribution of its staff and the student as the creator of an inventive contribution in their own right. That can really be quite a difficult situation, and it's not always a difficult situation for exactly the same reasons. One thing that we need to stress here is that the patent regimes in different countries are different in terms of the rights conferred. So for example, in the United States, if we have a situation of joint ownership, the joint owners are completely free to act in their own right without reference to the other joint owner. So in the States, a joint owner can exploit the invention themselves or grant licenses to third parties to exploit the invention without reference to his or her joint owner. Clearly that can create a lot of potential problems and pitfalls. In the EC situation, it's slightly different. Joint owners can exploit in their own right, but granting of licenses by joint owners in the EC requires the joint owners to confer with each other and reach agreement on how that's going to be dealt with, which is a more controlled situation. But there's more practical things than that associated with joint ownership when it's joint ownership between an institution and a student. For instance, a student is very rarely in a position to be able to contribute financially to the prosecution and maintenance of the intellectual property rights. They're usually people starting off their careers. They perhaps don't have a lot of financial resources of their own. And likewise, even universities are not really the types of organisations that directly exploit intellectual property rights in their own right. For instance, we wouldn't normally market products and services. We would be looking at a licensing model first and foremost. So there are often divergences of expectation and divergences of capability in terms of the joint owners when that type of situation arises. Likewise, in the current climate in the UK, a lot of emphasis has been put on entrepreneurial behaviour of students. A lot of students are being given entrepreneurial education, which makes them consider an entrepreneurial career much more so than would have been in the case in the last 5 or 10 years. And so to reflect on a definite example from my experience at Strathclyde after all that preamble, we had a situation where a student from our physics department was a co-inventor on a patent application with his joint supervisors. The supervisors are both members of staff in the university, so the university owns their intellectual property. The supervisors had not got the student to produce a confidentiality and assignment agreement in favour of the university, so the student owned his. So we ended up with joint ownership of a patent application. This student had received entrepreneurial education here in the university and decided that he wished to form his own company based around this intellectual property. He was supported by staff from research and innovation to start developing his business plans and so forth. And we always realised that when we got to the stage of company formation, we would have to find some way of structuring a deal that allowed the company and the student who was forming it to do what they wanted to do, and allowed for the possibility of some return for the university as well. What happened in the end up was that both the university and the student assigned our rights in this intellectual property in favour of the new company which was being set up. That meant that the company had completely clear ownership of the intellectual property going forward. But we also set up an arrangement where the university had a royalty stream based on the company's revenues, which we used to incentivise our inventors, the academic members of staff. And because we gave the company that level of support in its formation, we also treated this company as a formal spin out of the university, and we took an equity share in the company. And in fact, that company is doing really quite well at the moment. The company originally operated from within our university incubator when it was small with about 4 people, but within about 4 years of being formed it was up to about 30 or 40 people. It's now based in an off-site science park. In fact, it's in a different city in Scotland, in a science park, really doing really well, selling products into a number of marketplaces. And you know, we got over the challenges that were put in place as a result of a joint ownership situation arising. So it can be managed, and I would obviously urge anyone who finds himself in that situation, whether they are the student, the member of academic staff, or indeed whether they are someone in my type of role in a research services or tech transfer office. These hurdles can be surmounted. The key message, I think, is get in touch with our type of operation as soon as possible.
As David has explained for us, there is a great deal of variation on institution policy and practice. It's up to the institution to negotiate and establish ownership. IPR contracts should set out clearly who owns what in the materials produced within the partnership, and this should happen at an early stage. Each individual should know what rights they own and any restrictions that will be placed on that content for reuse. So remember, when you are creating intellectual property with another party, which is highly likely within BCE activities, even before you begin the project, think about negotiating prior agreements that are fit for purpose and address future reuse and ownership of any materials produced. Consider the particular IPR that's being generated and address any areas of concern, for example where you have a conflict between a publication right and confidential information. When issuing licenses and copyright statements for products that you create, make sure that you have the ownership in the first place and make it clear what users can and cannot do with it. Address any restrictions on this also. For example, if you have a condition on your funding that you should issue a particular license, then that will have to be adhered to. Thinking about issues and having suitable and explicit written agreements in place at the beginning of a project is vital in order to prevent later disappointments and disputes arising. If you wish more guidance or information on this issue, then please refer to the BCE themed section of our website.